Good morning. This meeting will be held with all of our council members participating in person. The public can join this meeting via Zoom. In order to allow the town clerk enough time to make sure that everything is working properly and folks are able to join the meeting, we will begin the meeting in about 5 minutes or so. Anyone who wishes to speak during public comment should type their name and address in the chat box, and you will be called on and unmuted when it's your turn to speak. Public comments that were submitted to the town clerk prior to the meeting will be read first. As usual, public comments will be limited to no more than 3 minutes. Thank you for being patient with us as we adjust to hosting electronic meetings. As it relates to public comment, anyone who wishes to speak during the public comment periods should type their name and address in the chat box. You will be called on and unmuted when it's your turn to speak. Public comments that were submitted to the town clerk prior to the meeting will be read first by myself or by Mayor Pro Tem or by the Mayor Pro Tem. As usual, public comments will be limited to no more than 3 minutes. Thank you.
Good morning. This meeting will be held with all of our council members participating in person. The public can join this meeting via Zoom. In order to allow the town clerk enough time to make sure that everything is working properly and folks are able to join the meeting, we will begin the meeting in a few minutes. Anyone who wishes to speak during public comment should type their name and address in the chat box, and you will be called on and unmuted when it is your turn to speak. Public comments that were submitted to the clerk prior to the meeting will be read first. As usual, public comments will be limited to no more than 3 minutes. Thanks for being patient with us as we adjust to hosting electronic meetings. Anyone who wishes to speak during the public comment period should type their name and address in the chat box, and you will be called on and unmuted when it is your turn to speak. Any comments that were submitted to the town clerk prior to the meeting will be read first by either the mayor or the mayor pro tem. As usual, public comments will be limited to no more than 3 minutes.
Thank you. The Town of Southern Shores Council Workshop meeting for July 21st, 2020 is now in session. Please join me in the Pledge of Allegiance. During our moment of silence this morning, I would ask you to join me in acknowledging the efforts of all of those who help make our community such a special place to live and to work. Please join me. Thank you. I need a motion, council, to approve the agenda for today's meeting.
So moved.
I have a motion to approve.
I'll second.
Second. All in favor indicate by saying aye.
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 The agenda for today's meeting has been approved. Are there any speakers for public comment?
Good morning. Is there anyone who would like to speak during public comment? If so, please type your name in the chat box.
This time I'll close public comment. Under item 3, business items, item A, A3, budget amendments, reappropriate money from fiscal year 1920 budget, tab 1. Do you wish to speak to this?
I can answer any questions the council may have. I can just share with you the two budget amendments. The first one, both are similar to ones you saw at your last meeting, and those are carried funds over from last fiscal year to the current fiscal year because while the funds were budgeted last year, the work may have started, but some of the work carries over to this year, so we need to make sure the funds are in the current budget to pay for the remaining work. For the police equipment, it's carried forward because the equipment was ordered in June. Won't be delivered or paid for until July. And then the facilities assessment that Flores is working on was under contract last year, but they're about halfway through the work. We've done the preliminary design for the code improvements, the ADA accessible improvements, as well as some other updates to town facilities. That work's continuing, and that's why both these budget amendments are necessary.
Thank you, Cliff. Need a motion, council, to approve budget amendment number 6 and 7.
So moved.
Thank you, Jim.
Second.
Need a second?
Second.
Did I hear a second? Not hear it? Thank you, Leo. Any further discussion?
I just have a couple questions. Mr. Flores is doing construction and design drawings for the improvements. So if this council decides to do just a portion of what is proposed, let's say we decide to just do the town hall, or decide to just do the Pitt Center. My question is, do his drawings, can they be used into the future? In other words, are they something that we can work off of? If this is a project that takes us maybe 5 years to complete,
Yes,
are
ma'am.
his drawings going to be useful to us?
Yes, ma'am.
Okay.
Provided there's no excessive code changes,
Right,
which I wouldn't anticipate, but the way we design this is because staff will have to come back to you once they're done. We've got a phased approach for each one of these buildings, so council can prioritize what needs to be done first, what needs to be budgeted first, and we can work through this in several years' budget. So we'll have a plan that we can use, like I said, 5 years into the future, but you can decide based on the priorities what needs to happen first. And
Okay.
so there'll be several different phases. Each building will have a phase. What we've asked Mr. Flores to do is to prioritize those. So that we take care of the most pressing thing first. If there's a accessibility issue into town hall, that'll be priority 1, phase 1.
okay,
And then we'll kind of work down from there.
okay. And that sounds very reasonable. And then my other question was, since this was all done by the previous council, I'm a little behind the curve. So is there any insight as to how the $220,000 figure was derived?
That's a good question. I don't know if Wes knows the history on how that number was figured.
I don't recall exactly where the 220 came from, but I know that Peter, Bonnie, and myself had discussions about what was provided in the initial assessment by the other firm. And we looked into that, and I think numbers were provided in that, and I think some of the numbers were pulled from it. there was a lot of work that was also, provided in that report that we decided that was not necessary, like painting, carpet, things like that. That's my recollection at the moment.
You know, thank you, as you know, there are no funds budgeted for any improvements. That was a number that, I don't know if had pandemic not hit, we'd be looking at recommending this expense in that amount, but my recommendation would be we wait and see. And I'm not sure that $220,000 should be a fixed amount. I almost think we should just start with zero and add as we need to, based on the priority. I mean, if we do it in a phased approach, then it could be 190,000, could be less. But because those funds aren't budgeted, I'm not sure if that number matters now.
And Mr. Flores is gonna prioritize based on code and safety
Yes, ma'am.
issues? And then,
down from there, I think there's maybe some public or some staff safety. There's some
Okay.
some things we want to put in place to just protect the staff,
okay,
and then they're not, I think it's the most pressing compliance issues, and then they're just kind of a step down.
okay, thank you.
I had just one question. Do you know what the police equipment is?
Yes, it's protective equipment. We've been asked to assist in a couple of demonstrations for public safety purposes, and we're not equipped for those type of
Okay.
events, so it's protective equipment.
Okay.
The police equipment was purchased last fiscal year
It was
under their budget from last fiscal year.
budgeted last fiscal year.
So you issue a purchase order, can it stay, I mean, I know we're doing it this way, but in the future, can that stay in that fiscal year's account?
Yes,
I mean, by virtue of purchase order, it should be able to be put in this expense.
yeah, I believe so. I mean, ideally, we'd like to see all the budgeted funds spent in that fiscal year, so it's clean and the accounting shows the year it was spent. I'd have to verify to make sure that we're carrying the money over, and if the purchase order funds carry over into this year as well. So it may show up in this year's accounting.
This will, if we do this amendment, but just
Right.
going forward, if something's been purchased,
Right.
it'd be nice to book the expense.
Yes, sir.
At the year.
I don't know our auditor a lot, but that's something you can check.
We were able to book our FEMA receivable. prior
As a
to
receivable.
Yeah.
A
we can
receivable.
book this as unexpended, I mean, anyway.
Yeah, well, I understand the broken.
It can show on the balance sheet that way, I would think.
Councilman Neal, I think it's going to come down to when the check's written.
Yeah.
Because what the requirement's going to be that the funds have to be budgeted at the time. So for the check to be written, the statute requires that the funds be budgeted at the time. So that's probably where the issue of there might be a PO, but if you didn't write the check in the prior fiscal year, then you've got to have it in the budget to write the check in the future fiscal year.
That's the nuances of private and public
The
accounting.
only reason I asked is in the audit, there were a couple of expenses that were booked that weren't actually expended yet, so that was, anyway, it doesn't matter, I'm ready to vote.
So we have a motion and a second. We had some discussion. Is there any further discussion? I want to add one quick thing before we vote on this. We can hear each other pretty well in the room, but the recorder who's taking our pictures on video is not hearing this, and we aren't speaking into the microphone. It just doesn't show up well on the soundtrack when you replay this. So I'd ask you to speak into the mic as much as possible. We have a motion and a second. Discussion. All in favor of approving budget amendments number 6 and 7 indicate by saying aye.
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 Aye. Motion was made and carried unanimously to approve budget amendment number 6 and 7. This time I'll call on our town attorney to direct a public hearing for us.
Thank you, Mr. Mayor.
Thank you.
The next item on the agenda is a public hearing related to ZTA 20-01 regarding temporary emergency zoning accommodations. This is a legislative public hearing. I I can't remember if I've done one on Zoom yet or not, so this is going to be a little bit new for me, but I'll have someone check the sheet, which I don't believe there were any sign-ups, but if someone could take a look over there and see if there are any sign-ups. I will go through those first, and then I will, as Mr. Haskett did earlier, I'll ask for anyone who has any public comment to type their name in the Zoom chat area, and we'll call you from the list of names that come up there. The first thing I'll do is, Mr. Haskett, are you going to be the one speaking to this, or I'll have Mr. Haskett give his report, and then we'll open the public hearing and take public comment. So, Mr. Haskett.
Thank you, and good morning, Ben, Mayor, members of council. The next item on your agenda is ZTA-20-01, and it is a zoning text amendment application submitted by the town to amend the Southern Shores Town Code by amending Section 36-416, Planning Board Action, and by adding Section 36-177, Temporary Emergency Zoning Accommodations. At the May 19, 2020 Town Council meeting, the council read and considered a letter from the president of the Outer Banks Restaurant Association requesting that Dare County and all of its municipalities consider allowing temporary accommodations for businesses impacted by the COVID-19 pandemic. Specifically, the letter requested allowing restaurant carts, kiosks, and food trucks on their operational premises, and allowing outdoor dining since Phase 2 of the governor's Safer at Home order restricts restaurants to 50% capacity. As a result of these requests and the circumstances involved, and after hearing recommendations from the town attorney, council agreed that the town's declaration of a state of emergency should be revised to allow for reasonable temporary accommodations in the town's zoning regulations as a short-term solution. Council also directed town staff to draft a ZTA to address the requests. During that discussion, the town council recognized that the town zoning ordinance currently requires the planning board to have a minimum of 30 days to consider amendments to the town zoning ordinance. This prevented the town from being able to quickly address the requests in the form of a ZTA application, as recommended by the town attorney. As directed by council, town staff is proposing to amend the Southern Shores Town Code by amending Section 36-416, Planning Board Action, and by adding Section 36-177, Temporary Emergency Zoning Accommodations. The proposed amendment to Section 36-416 removes the current requirement for the planning board to have a minimum of 30 days to consider amendments to the town zoning ordinance. The proposed Section 36-177, which would be a new section, allows for the mayor to authorize the town manager or his designee to exercise their discretion to allow for reasonable temporary accommodations in the town zoning regulations consistent with and furthering the purposes of a declared state of emergency and in the interests of public health, safety, and welfare, including the economic prosperity of the community. Such temporary accommodations cannot extend beyond the termination of the state of emergency or the end of the circumstances under the declaration causing the need for accommodations, whichever is shorter. All temporary accommodations must be ceased within 5 days of the expiration of the temporary accommodation. The town's currently adopted land use plan contains one policy that is applicable to the proposed ZTA, which is Policy 2. With respect to the recommendation, town staff has determined that the proposed amendments are consistent with the town's currently adopted land use plan, and the town planning board unanimously, 5-0, recommended approval of the ZTA on July 2nd, 2020 in a special meeting. I think you're all aware that Planning Board Chairperson Ward has requested that council allow the planning board to take another look at the proposed amendments to Section 36-416, mainly to revisit some of what was discussed at their July 2nd meeting, which was to only exempt the 30-day requirement during a declared state of emergency. From a staff perspective, if council decides to send it back to the planning board, we'd be glad to work with them. And I'd also suggest that they also consider adding an exemption for ZTAs that are requested by the town council. That concludes my staff report. Ben, if there are any questions, I could try to answer them now.
Does anybody on council have any questions for Mr. Haskett? Hearing none, I'll move on. Thank you, Mr. Haskett. I would point out that with regard to the questions that have come up about the 30-day requirement, first of all, this isn't the first time it's come up. I mean, in the last 3 or 4 years, it's come up at least 3 times that I can think of where the town council wanted to act faster than the ordinance would allow, and the ordinance disallowed them from doing it. The issue that comes up is I believe Mr. Ward has referenced that it takes away the 30-day period for the planning board, but the only change it makes is to Part B, not to Part A of the chapter of Section 36-416, which still requires that if no written report is received from the planning board 30 days of referral of the amendment to that board, the town council can proceed in its consideration without that recommendation. That tracks the statute. The language that's being removed from Section B is not in any statute. It's an additional limitation. It's actually a limitation on the planning board as much as it is on the council, and it takes away their authority because it doesn't allow them to even consider it for 30 days if they wanted to. So the way the statute works is if the planning board takes more than 30 days to come up with a recommendation, council can move forward without the recommendation. But what this says is that the planning board can't even take it up and consider it for 30 days, and then has another 30 days that would be the statute, which could put you, well into the 50, 60, a large number of days before you can do anything. And that limits them from, if they were able to and interested in considering it much quicker, they can't do it. So taking away the section in B, which also I represent a number of towns. I have appeared in front of other towns. I haven't ever seen this sort of provision in anywhere but Southern Shores. And when Wes and I ran into it a couple years ago, it surprised me that it was in there. And I hope I didn't ask anybody to put it in there at some point in the past. That would have been a mistake. But it doesn't take away the fact that the planning board still has to have 30 days if it wants to consider it. So I just wanted to explain that so that I know there's some consideration about sending this back to the planning board for dealing with that issue. I wanted to make sure everybody understood what it meant before they made that decision. Now, we're going to open the public hearing. There's no one signed up here. Al, you don't want to speak? Since Al's the only person here, I figured I would ask him. Does anyone wish to sign up on the Zoom chat? One last call. Anyone want to sign up on the Zoom chat? I'm not seeing anybody. Wes, am I correct in my view of that? I'll close the public hearing. Mr. Merritt, it's back with you.
Thank you, Ben. Have a motion, council? What's your pleasure?
Can I ask Ben a question after I get some water?
Sure.
May I ask Ben a question?
No.
After you get some water.
Just holler.
It's a red blinky light instead of a green when I walk by.
I'm gonna take my mask off so you can hear me. And some of the concern that I discussed with the planning board chair after they unanimously supported it was, I think you clarified a little bit, but is this a fact that this elimination of these two sentences does not diminish the planning board's authority to have 30-day review of issues before the board? I can rephrase that once.
Good test of Mr. Haskett's battery changing
That was pretty quick.
agility. Yes, it doesn't take away the statutory 30-day provision that the planning board has 30 days from the time it's referred to them to make a recommendation. That's still there, and if you wanted to take that out of the ordinance, I would tell you you couldn't, because that's a statutory requirement as well. But what's being taken out is, in addition, added at some point by a council in the past.
And when I went through the other town zoning, this particular sentence, no proposal shall be considered by the planning board within 30 days of the filing, that's very unique. It's not anywhere. Kitty Hawk does have a certain days that the planning board may be able to have a recommendation, but everybody else, in fact, most of the other zoning ordinances for other towns implores the speed at which the planning board should give recommendations to council so that they can hear it at their next meeting.
Yeah, and there's nothing about this that doesn't allow the council to slow it down if it wants to. What this really is there have been multiple occasions where we've run into a situation where you want to act faster than you can because your own code gets in your way. And another part about this too is you're still not going to be able to act much faster than 12 to 14 days from the time you think of something, because there's going to have to be the planning board doesn't have to have a public hearing. That's not a statutory requirement, but the town council on zoning amendments does. And to do that, it has to provide 10 to 25 days notice. And then there's, if you wanted to have an emergency meeting or special meeting with council or special meeting of the planning board to get it done, they're going to have 48 hours notice. So in general, the fastest you can do it's about 2 weeks.
No.
But where it was a significant limitation on how fast the town council could take action on a zoning text amendment.
That was what struck me. I mean, the date of Wes's signature on here was June 2nd, and because of this, the planning board couldn't hear it until July 2nd, so it sat dormant for 30 days. The other policy question I have is from the application of a ZTA from a private citizen or somebody, they will be asked to have that application in place 30 days prior to a planning board meeting.
Yes, sir, that's correct. The planning board adopts a schedule at the beginning of each year that sets their meeting days, and it also establishes the deadline for applications, which is 30 days prior to the meeting date.
Yeah. So then when the application's received and filed is when the 30-day clock starts before council consideration.
Yes, sir.
So theoretically, for an application to be valid, they have to have it 30 days for the meeting. And then the planning board can meet, and then we meet 2 weeks later, we can take action.
Yes, sir.
That was my other question. There's just a couple date things.
And you could also do it a little bit faster by preemptively setting a public hearing that you expected something to come from the planning board with a recommendation.
Well, I think my other concern was just talking to the planning board chair. I think he didn't want to get sandbagged and have to move on something, but because the applications from our citizenry requires a 30-day prior to meeting, they have that review period built in. They can adjudicate, and then it can advance to council. The only real person that might be able to accelerate the timeline is the council or town staff. If they submit, because our application deadline, if we ask for something, is it has to be 30 days prior to the meeting of the planning board.
I would look at this as the language is referred, and I think that what this council often does is refer things to the planning board via vote. I think the 30 days probably starts from the time the council refers something. With regard to the private ones, I would consider at best when the agenda is sent to them as the 30 days, but it may be even from the meeting that they first consider it, because it's really the concept of when it's first in front of them, when they can first start looking at it, and they could decide to have a meeting if they felt they needed to have a special meeting or 5 special meetings or whatever. They're their own independent body in that regard.
But
So once they know it's there and available to them, I think that's when the 30 days starts. Not just the filing
They have that 30-day
date.
review period fixed in, it's baked in, it's not taken away, but they have the option to say, we want to hear that a little sooner, we want to take action, and once they've taken action, the council can hear it sooner.
Yes.
And that's what we're enabling the planning board to do.
Yeah.
I think that's was where the confusion lay.
Any further discussion? So the recommendation from the town staff that the proposed amendments were consistent with the town's currently adopted land use plan, and the planning board originally unanimously recommended approval of the proposed ETA on July 2nd, 2020. All in favor of adopting this ZTA?
Need a motion.
I'm sorry.
We need a motion.
Need a motion.
We need a motion.
I would like to make a motion to adopt ZTA 20-01 as recommended by the planning board.
I'll second.
That's what I was getting ready to do, to make a motion. I got it. Any further discussion? If not, I'll call for the all in favor.
Aye.
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 Motion's made and carried unanimously to adopt the planning board's recommendation.
Before we shift, I'm gonna throw a bomb at Ben real quick. Some of this, I was looking through code rights revisions of this section, and they have a fairly ominous paragraph that says this is clumsily written and blah, 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 and needs full review, which is interesting because they're a consultant to review our code. At some point, we need to look at adopting their recommendations, and this section in particular looks like it needs a little bit more time, and I would say to the council, especially given Chairperson Ward's concerns, that we let him take this section on a little bit when we get into that. But where are we at with the code rights?
It's with me. I have not put it as the priority that it's needed to be, and I'm hoping to get it to the council, my recommendations and review by the August meeting.
Really? I mean,
yeah.
I wasn't gonna put that kind of
No.
deadline. I mean, I was just curious. more
No, I
than
mean,
anything.
no, that's
we've
been
had
my
that a
hope. My
while.
hope was to do it the meeting before, and the meeting before that, and
Yeah.
the meeting,
I
all
mean,
the,
nobody's gonna be mad
all the
at you,
meetings
no.
since I've had it, but the zoning chapter that I'm looking at in general is pretty long. It's close to impossible to figure out what's been changed and what hasn't been changed. So I'm having to go through line by line and determine whether or not whatever's there, whether it's been changed or not, is somewhat okay or needs to be changed or needs to be modified. And that's having me, when I sit down to do it, I've got 3 screens up, and I'm looking at what was there, what isn't there, and Westlaw and other information, trying to figure out, okay, what hadn't been changed, or what's right about this or wrong about this. And the other part of it too is with tracking the changes, because there was so much movement of stuff in and out of the zoning
Yes.
ordinance into other chapters, I've got to pull up the zoning ordinance, and something may look like it's right, but if it references something else, I got to go look at that and see if it's right, and then I got to worry about from the code that existed, okay, there's another paragraph here, where did it go, why did it go?
Yeah.
And I've got to figure out what happened to it, and it's really 2 nonstop days worth of work that I haven't had an opportunity to put everything else I've got to do down and just sit down for 2 days and do it. And that's really where it is. Once I'm done with that, I will come back. I mean, I know there's some issues like that Chad said that were clumsily written. I believe that's
He says that several places.
yeah, and that's sometimes right, sometimes wrong, I think, in that sometimes it's clumsily written the exact way the statute's written. And so while it's clumsy, it's legal, and sometimes, and there's also some things that Chad comments on that were stuff that he didn't, misunderstood, I think. So that it's just a long process that I need to have 2 days to sit down and do it. And my plan is, now that I've said it publicly too, I guess it probably will happen if I have to do it on a weekend. But,
I didn't mean to put you on the spot.
no, but-
August. I'm more curious, like, what's our process? Is this, we'll have a public hearing and adopt it? Because it seems like, I was reading through it, after I read that section last night, I started reading through other sections, and it's not a complete document.
No, I don't know exactly where it stands. I think Wes can speak to it, but I think I think Code Wright's position is it's pretty close to being adoptable. I think it's really up to y'all about whether or not to do that. I think it's up to y'all about whether or not. I'm not sure that I'm not sure that I've got the issues with what you have currently
One day,
that Code Right has. I think you've got to balance whether or not you like what you have currently and would rather make smaller incremental changes to it, or whether you'd like to you like Code Rights better and would like to go with the whole thing, or if you like some parts of Code Rights and you'd like to integrate it into what you have. And But that's really a decision for council.
Once you finish, doesn't it have to come back to the planning board for review before it comes to us?
I think the planning board's already had a
They
public
had it,
hearing
but
on
for some
it,
reason
but-
I thought it had to come back, was to come back. Now, I may be incorrect.
The planning board had already looked at the chapters that they needed to look at, and then it was all submitted to Ben for his review. And once his review is complete of the zoning chapter, that will be sent back to Chad for Chad to make changes necessary. And then it will all go back, that will be the adopting or adoption document is what we're going to refer, is what it's referred to as. And the applicable chapters that need to go to the planning board will go to the planning board for their formal recommendation, if that can be obtained. And then the adoption document would then be forwarded to council for adoption.
I'd like to make just one comment. This thing has been around our neck for many years, 5, maybe 6. That spans through 3 different council seatings here. Anything we could do to get that albatross off our neck would be very much appreciated on your part, because it sounds like even after you've spent 2 days on it, we're still months away from getting this thing passed.
And it is a big I mean, it's,
Yeah.
you can look at what we got today, right? You've got a 2-paragraph change to the code that took multiple meetings, that's taken a bunch of, there have been emails, there have been calls, there have been meetings, there have been discussion, you've had a public hearing on it, and that's 2 paragraphs.
I
out of one
understand
part.
all that,
And
but
so-
5 years is a
Oh,
long
yeah.
time.
I don't disagree,
And
I'm not
it's-
disagreeing.
I personally think that it's time to wrap this up.
I
And
agree. And
Have you had a chance to look at the revisions, the new proposed?
no, sir.
I mean, I'm not in any position necessarily to rush, especially if, like, you to be able to sink your teeth into it too. I mean, after Ben gets his revisions and things. I was just curious. I said I was gonna throw a bomb at you, but I was joking. You can have till December.
Well, I've told others, it's when the COVID shutdown came together, I left the office the day that I left the office to work from home for a while with 2 things in my hand, one of them being a notebook to be able to do this, and found that I was even busier during the COVID. I thought that here's an opportunity to have nothing else to do for some period of time. Everything's going to shut down, but I was just as busy or busier during that time frame and wasn't able to spend the time that I need to do it. But it's on my list of things to do, and and it's been just as much as the whole thing's
just
been
gave me
around
something
y'all's
to-
neck. This has been around my neck for a while, something that I remember every day when I walk in the office and just don't have an opportunity to pick up and finish.
Well, please understand, I'm not blaming you. I'm not putting this off on your shoulders. It's the whole town this thing has just languished forever. And like I said, just speaking personally, I think it's time to wrap this thing up.
I'll get my part done out of it and let y'all move on.
You're gonna put the monkey somewhere else.
Yes, sir.
That's always fun to do.
He runs up and down the table.
He tends to keep a string on my leg when I put him somewhere else, and drag me back into things.
Moving ahead, I think, to item 3C, Resolution 2020-0703, Beach Nourishment Legislation Resolution, which is tab 3 in your book. I'm going to make a motion that we adopt the attached resolution requesting North Carolina General Assembly to consider adoption of legislation authoring the town to acquire the use of property for the purpose of constructing a beach nourishment project. Do I have a second?
I'll second that motion.
Any further discussion?
Yes. Can we limit this to just subdivision 10 of the subsection?
I can't hear you, Matt.
Can we limit this to just subdivision 10 of the subsection? I mean, I was, just say subdivision 10 of this subsection shall apply to Southern Shores. And that's the change, rather than adding us to the list of all the other towns. I mean, there's authorities in here that we don't necessarily, like building hospitals
You're already in that list. I
and
mean,
with the
there's a-
resolution as written.
Yeah. Well, no. You're in that list either way, because what it is there's two sections in the thing, and one of them has 1 through 9, and one of them has 1 through 11.
Yeah. I'm
And
sorry about that.
everybody has 1 through 9. And a certain group of towns has 1 through 11, and Duck has 1 through 10. And
Okay.
you would be added to the list that has 1 through 10, like Duck. So it's a,
How does that work?
It's a really-
Everybody has 1 through 9. Is that the
every,
second?
there's a
part of-
separate section.
Yeah.
Let me pull it out. I'll look at it.
Because I think that's where some of the grief comes from, that there's this overarching authority that we're seeking to appoint. I mean, in my view, the authority that I would like to seek should be narrowly tailored to the beachfront, which the use of that property has already been restricted by the state.
What you're modifying is section 48-3, or what you're requesting to be modified is section 48-3B1.
Yep.
B1
That's
is
the
what you're
list of the
changing.
1 through 11.
But you have, but when I say B1, it's not the typical B in a parentheses and a 1. It's a B1, like right next to each other. And what that means is right above it, there's a B.
Gotcha.
And B has
1
the
through
exact same list of 1 through 9, but it applies to every local government, local public condemnor in the state. Municipalities, I had to go look and see what other local, but there are sanitary districts, there are other local public condemnors. 1 through 9 are in all of those. Everybody has those.
Section B.
But then there's a section B1, which is what you're seeking to be added to,
Okay.
and that section only adds 10 and 11. And 10 and 11, 10 is your typical beach nourishment purposes, and 11 is beach accesses. And then it has a list of the municipalities that have that authority.
That B1
So you're,
section.
yeah, just 10 and 11. So you're being added to that authority. But you're not being added under this resolution. You're not requesting to be added to the authority to condemn via the eminent domain beach accesses. But the rest of the authority that's listed in B1 is the same as what's in B. And you already have that, whether you're in B or B1, whether you're in this list or not. So the only thing that's
We
changing
already have that right now.
right now, okay, because you're a local public condemnor that's not listed in B1, you fall into the B category, which every other local, Raleigh has the same authority, which, clearly they probably don't need to open, widen, or extend or improve any public wharves, but they would have that authority.
Yeah.
You've got all the 1 through 9 authority already. Similarly, in the discussion about the accelerated condemnation procedures, again, you've already got a fair amount of the authority in 1 through 9. You've got section 1 under B, 4, and 7. And then I think you might have you've got some other authority as well. So you've got some of that authority under the accelerated process already. So really, all this is adding. It's the only authority it's changing for you is the authority to do beach nourishment related condemnations and to use the accelerated process associated with that authority. Anything else, you already have that authority.
So this actually is narrowing it down to just the beach area.
That's the only
Yes.
authority it's at.
Yeah. This is similar to isn't this similar to what Duck has?
This is exactly what Duck has.
Yeah, that's what I thought.
It's lesser than what every other town has. Every other town, not only every other town, but Carteret, Dare, Atlantic Beach, Carolina Beach, Castle Beach, Emerald Isle, Holden Beach, Indian Beach, Kill Devil Hills, Kitty Hawk, Curie Beach, Nags Head, North Topsail Beach, Oak Island, Ocean Isle Beach, Pine Knoll Shores, Sunset Beach, Surf City, Topsail Beach, Wrightful Beach, and Village of Bald Head Island all have also the beach access condemnation authority. Duck is the only one in the list that has the beach nourishment condemnation authority that does not have the access authority. and you will be number 2 in the list that
So,
would have, if
We,
this passes.
we'd be limiting ourselves to that
Yes, sir.
area.
Yes, sir.
Can you clarify the easements that we're pursuing here to do beach renourishment? Is the town actually taking title to that property, any part of that property?
It's taking title in the form of an easement. It's not taking fee simple title, which is ownership, which is your typical ownership title. It's not a permanent ownership. It's a limited rights to do limited things.
Which is for the way we have done it in the past, is for a limited period of time.
It can be for whatever, I think, the concept is to get voluntary easements for some period of time.
I understand all this, but
Yeah.
the public is being grossly misled as to what this is all about.
And different towns have asked for perpetual or for 10-year easements. And whatever people are willing to voluntarily give you, that's what they're willing to voluntarily give you. And
But this resolution is for those who will not voluntarily grant us an easement.
if there's someone who doesn't voluntarily grant you an easement and there is a need to get an easement, this will give you the authority to condemn it if you have to.
But we're talking about an easement, not a fee simple title.
Well, it would give you it's going to give you the authority to condemn a fee simple title. But that doesn't mean you have to exercise that authority. I mean, all these other authorities give you the authority to condemn fee simple title as well. But you always get to choose as a body, the town gets to choose what it condemns. It's not necessary to condemn ownership.
Did
of
we
that
do
easement.
a fee title condemnation for the Pelican Watch renourishment effort?
No, those were easement. Well, we didn't do any condemnations. You didn't have the authority. Those were all
Exactly.
voluntary, and those were all easements. And I'm not aware of any towns that have done any fee simple there may be somebody who has essentially sold their property to a town or given their whole property over to a town, but usually for nourishment purposes, it's easements. I mean, I haven't dealt with a town that's done it otherwise, in their process of seeking their nourishment process. Nags Head got voluntary easements for an enormous amount of the land area. Kill Devil Hills ultimately got voluntary easements for, I think, all of their project area, and Kitty Hawk came pretty close to that too.
I don't believe Duck condemned any.
And Duck got voluntary easements for all of its project area, and that's typically what you see.
And Southern Shores did for from the Pelican Watch folks.
Yes, sir. Yes, sir.
I don't know if it's possible to simplify all this in a way that lets people know that we are not doing a taking where we obtain title under that, what do you call it, the fee?
Fee simple.
And I think that's the problem, is that it's going to revolve around, just the word easement is a relatively complicated legal term. I have litigated some cases where I had to ask people who were very, very smart people, what do you think an easement is?
Yeah,
And they
define
say, I don't know. And I think that's what it's going to come down to from explaining it to lay people, is that the best you can say is, we're not taking ownership of your land to be able to do whatever we want to do with it. We're taking, or you're voluntarily providing, or we're using, or whatever, an easement, which is a limited right for specific purposes to do specific things.
Exactly, and a boatload of properties in Southern Shores have easements on their property already.
Most of them do. I mean,
Most of them do.
All of them do.
I know mine does, and there are easements granted to the SSCA before the town was incorporated, so for utility easements.
Yes,
So,
sir.
I mean, this is,
It's not new.
The way an easement works is the easement holder can use it for the purposes of the easement, and then the fee simple holder, the owner of the underlying property, can use it for any other purpose that they could normally use it for, as long as they don't block the easement holder's
right.
ability to use it for their purpose that they've got on the easement. So if you take, for example, a power line easement, if it runs across your backyard, you can use your backyard for whatever you've got as long as you're not messing up the power company's ability to run its power lines across that easement that it's gotten from you, however it got it from you. Same thing, farm easement. You'll see an egress easement across somebody's farmland to get to another piece of property at the back of it. And, really, as long as the farmer who owns the land doesn't make it so that road's not passable, he can put a gate up as long as he gives you a key, and as long as the easement holder can use it for the purposes, the farmer owns that land and can use it for whatever his purposes are, as long as he doesn't block that guy from going in and out. And that's exactly what this is it's an easement.
This is a lot like a utility easement, basically.
And it's even less than a utility easement in that it's on the ocean front solely. It's on an area that can't be developed. Nothing else can be done there. And it's already subject to public trust rights and the public usage rights. And there's a pretty good position that you don't need an easement, that, beach nourishment is something that you can do. It's still in litigation whether or not that answer will come out one way or another, but there is still a chance that you don't need an easement to do beach nourishment on the ocean front. But what this is a tool that's in your toolbox that will, if you have it available and have to use it, it will allow you to perform a beach nourishment project in the manner it's designed to be performed.
Thanks.
Ann wants to speak, and she's asking permission from
you to
from
speak.
you to speak, even though it's,
I think Mr. Al wanted to speak as well.
and after Ann, Al would like to speak.
Ann, you should be unmuted.
Okay, thank you. Good morning, everyone. I appreciate this unorthodox intervention here. Ben, I just wanted to ask you, you were distinguishing B and B1. The problem that I have with it, and it's similar to what Matt is talking about, if you read 40A-42-2, you'll see that there are 5 subsections in which quick take applies. Subsection B11, B14, B17, B110, and B111. So really, to me, the difference between B and B1 is that you're giving quick take condemnation to the specific towns for these 5 purposes. And what I think Matt was trying to do was limit the public use purposes to just the beach nourishment, which would be number 11. Now, if you disagree with that, I'd just like your interpretation of how you the 2 sections together.
And there's an easy explanation to this. It's very similar to the B and B1 in 48-3. In 48-42, there's an A1 and an A2. And
Right.
in A1, it applies to all local public condemnors, and it's the same list as in section 2 that you just cited, minus 10 and 11 from 48-3. So that it tracks the same way as B and B1 and 48-3 did. The town already has quick take authority, like I said, under section A1 of 48-42 for sections 40A-3B1, 4, and 7. And then
Right.
if you look at section 2 there that you were citing, it lists 1, 4, and 7, and 10 or 11. And I went through a minute ago. I'm pretty sure that the numbers track for the other numbers that are cited there, but
But isn't 48-42A1 standard condemnation and not quick take?
no.
Isn't it standard 120-day eminent domain?
I don't
And
believe
not-
so. The way you look at it is, and it's it's an awfully long sentence. I think the whole paragraph is 2 sentences, but if you look at the very end of the first sentence, title to the property and the right to immediate possession shall vest pursuant to this subsection. That is the quick take authority.
Well, I guess we just disagreed, because I don't see where it refers to B1 at all.
Where what refers to B1?
That section you're reading, that to me
It
is
does- it-
standard eminent domain.
It
By a
doesn't
public-
refer to B1.
and then-
B1
and then
doesn't
the
have
quick
anything to
take.
do with quick take, Ann.
Pardon
B1
me?
is your authority. All of your quick take provisions are in 42.
42A2.
No, 42A1 and 42A2 are both quick take provisions. 42A2 is just an additional quick take provision for certain localities to be able to add 10 and 11 from 40A-3, B1.
Ben, is there anywhere that this has been interpreted,
Yes.
by an independent authority, like the School of Government?
You can ask them if you want to. I think they'll give you the same answer. And the Court of Appeals came up with a pretty close answer in the Fisher
Okay, well,
case
if
and
you have
Nags
a
Head.
case citation,
Ma'am?
is there a case?
The Fisher case talks about the authority to do it. It probably goes through this, but it's not going to distinguish. I think if you go through and compare the language of A1 and the language of A2, they're going to be the exact same.
Yes,
except
they
for,
are, and that's very confusing. And the way I was distinguishing it was, one says standard and one says modification.
Yep,
So I read it as,
and it's
I'm sorry.
modifications for certain localities. The standard provision, I'd had to pull up 40A to look, but there's another section that talks about how you do condemnation. Everything in this subsection is about, Section A is quick take. All of it is quick take. And the way you know that it's quick take is, the only thing that quick take does is one thing. Title to the property and right to immediate possession shall vest pursuant to this section.
And that is not what we're doing, is that correct?
No, you're adding that for your beach nourishment authority, but you've already got the authority for the other.
For the others, right.
We're just adding it to the beach
okay, I'd like
nourishment
to say
side.
just one last thing, and then, I'd just like to say one last thing, and then I'll stop. The problem here, I think, with the public is that you actually are giving, you're gonna have authority to condemn and take fee simple title if you go along with it. There's no doubt about that. So the issue is whether the public trusts the town to just take term-limited easements. And that's why there's an undercurrent of distress, because you actually are being given authority to take title by quick take. Question is whether you do it or not.
Mr. Mayor, I'd like to suggest that we have right now here North Carolina attorney Ben Gallup arguing with somebody who is not a North Carolina attorney over legal issues on a very complicated issue.
Mr.
I'd like
Connors,
to
I was
suggest
being
that we
very
just
polite,
move on.
and you don't even
I'm
understand.
trying to wrap my
it.
mind around this, and it's helping a lot to have this discussion. So, under a standard provision, which is already granted to the town, I can condemn fee simple title, property over there to build a wastewater plant, stormwater drainage, playground, hospital. That authority exists today. So does everybody hear that? I can already theoretically, as a council member, take the land and develop it through this quick take provision. The only authority that is being altered or amended or changed is to have an easement or a quick take authority to the oceanfront parcel of your land. And the oceanfront parcel of that land that is eastward of the standard veg line, you can't call the police on a trespasser. You can't develop. You can't use it for lot coverage purposes. It is already, the use has already been practically condemned by the state. Now, that's probably not a legal example, and Ben will jump all over me, but you already don't really have the use of that property in the same way you would your property westward of that veg arm. Is that a fair statement?
Exactly. You can't keep someone off if you're sitting in your house looking towards the ocean, the area that's east of the top of the dune, it might belong to you, but you can't throw anybody off the beach. The public has a right to be on the beach. They can put their chair there and stay there all day, every day. You give up that right to keep people off the front of your deck, so to speak.
I think there's some understanding that part isn't necessarily the issue. It's that there's a further quick take authority that we could take land arbitrarily through this resolution. And the way I'm hearing it, that discussion was really helpful. We already theoretically have that authority. I mean, if we voted to condemn, or it refers to a board of education, and I don't want to muddy the water by trying to figure out how that process works, but we already theoretically have this authority from the legislature to take a piece of property in the hills or down by Ocean Boulevard or something else to modify it for some of these purposes that I was initially thinking we should be excluded from, but it's already there. Is that a fair statement?
Yes, it is a fair statement. And to follow up with one last thing to point out to Ms. Schursma so that she can see where it is the way to see the difference. Section A of 48-42 is the quick take authority. And then Section B says that when it's not taken for a purpose in Section A or under Section A, then here's when title vests. And it gives you 3 times. And that's the distinguishing point. A is authority, title vests when you file the action. B, title vests farther along in the action, but still vests. And additionally, the quick take, people call it quick take authority. It's an accelerated process for being able to get on the property, but ultimately you can file an injunction beforehand, which isn't allowable for a quote unquote normal condemnation. And also, you can ultimately prevail on the concept that the town couldn't have taken it if there wasn't authority. It doesn't keep you from prevailing. It's a time process. It's a timing situation where if you need it, then you would want to wait till the last minute that you have to use it, and you want to be able to get on the property and do what you have to do immediately rather than have to wait some period of time that, particularly where you already have the authority, there's not going to be a question. You're just going to be delayed. That's all that the quick take does. You can take it. It's just a little bit. It's not much slower the other way. It's just that you can go ahead and you can determine when you start to use the property if you need to. And all of this is a need to. If you don't need to, my hope is that you never have to file anything related to this.
It's an easement,
Yes.
and our efforts are going to be on obtaining voluntary easements.
Yes.
And I think it's important to point that out, that what we're taking the right to is what's described in that easement. And that easement language will be very narrow, that only gives us the authority to perform the beach nourishment project. And that those activities allow the contractor to be able to move in that easement area to perform the project. And once it's done, then
Right.
they're gone. And it's only a very short period of time that equipment and contractor will be on the beach.
Al wanted to speak. Can you come up to the microphone?
I just wanted to clarify something, and it's that first, the easements are going to be tried to be gotten voluntarily, correct? Okay, you're going to go through that before going to the commendation. Okay, and then, Ben, you got me a little confused because you keep saying under 10 and 11, okay? And I had believed that 11 had been eliminated.
Yes. 11 has been eliminated from what the town is requesting. But the difference in B and B1 that we were talking about under 48-3, there's a 10 and 11 in B1 that is not in B.
Okay.
But the resolution is only requesting that Duck have the authority under 10, not 10 and 11.
Okay.
All the or did I say Duck? I meant Southern Shores.
Southern Shores.
Southern Shores is only going to have the authority under 10 and not 10 and 11, like Duck did. But unlike all of the other coastal
Right.
towns, which have the authority under 10 and 11.
Okay, thank you very much.
Yes, sir.
Can you, not to belabor this, but can you describe a little bit further the difference between a fee simple taking? I don't want people to think that they no longer own property as a result of the action that we're taking.
Well, the law school example of how you deal with real property is a bundle of sticks.
Right.
Okay, so you own a piece of property, you own the whole bundle of sticks. And when you give out a utility easement to, that's part of your, when the developer gives it out as part of your plat, he took out one of your bundle of sticks and he's given that right to some other people. But the bundle of sticks are the rights of what you can do and what you can keep other people from doing on your property. And if you own the fee simple, you own the whole bundle of sticks, and I'm out of order again, and you can limit people from doing things on your property, and you can do things on your property. When you own your property, like Matt said, or Mr. Neal, excuse me, there are often utility easements that pull little things out of your bundle of sticks, but you still own the bulk of the bundle. Same thing with a beach nourishment easement. It's going to take a stick out of your bundle because it's going to limit your authority to stop people from doing beach nourishment on your property. If you had that authority. Well, we'll make the assumption that you have that authority as part of your bundle of sticks anyway, because you might not. But if you have that authority, then when you give that easement away, what you will be doing is limiting the authority to say, no, you can't do beach nourishment on my property. That's it. That's what a beach nourishment easement is. Just like a utility easement is, you're limiting the authority to say, no power company, you can't run a power line across my property. Oh, I've given you an easement? Sorry, I can't limit you from doing that. That's what an easement is. But you still own the underlying property. You still own the house. You still can rent the house. You can still be at the house. It's not meant to take any of your ability to get to the water. It's not meant to take any of your rights to do other things related to the water. It's merely giving the town, you're giving the town your right, your prior right to limit them from doing beach nourishment on your property if you had that authority. And they'll be able to do beach nourishment. That's all an easement is. It's permission to do that particular thing that easement language gives. Whereas a fee simple is ownership. That's when you go and you build your house there and you live there. And ownership would mean that if you gave fee simple title to the town for the land where the beach nourishment is, it probably wouldn't make much difference because the town can't build much there either. But for the land where the house is, if you gave, fee simple title to the land where your house is, then they own it. The town can go and build a new town hall or do whatever it wants to there. But that's not what you're doing. And here the town's not going to be seeking easements from the road through your property to the beach. The easements that we're talking about are only along the beach. They could, theoretically, there are reasons for somebody to have an easement that would go from the road to the beach. And you might be more, someone might be more reluctant to provide an easement like that because it might interfere, it might be a bigger stick out of their bundle in terms of interference with their ability to use their own property. But beach nourishment easements are typically considered to be a very small stick out of a very big bundle because they're very, one, they ultimately benefit the property owner to some degree, and two, they are not taking away a big portion of rights that the property owner already hadn't been restricted upon because the property owner On the rest of their property, they have the right to exclude people. They have the right to exclude commercial fishermen. Commercial fishermen can't come up and sit on their porch. But out on the ocean front, they've already lost that bundle of rights. They've already lost the right, or technically they never had, because it transferred from the very beginning, but they never had the right to preclude people from walking up and down the beach, or to preclude people from fishing, or to preclude people from public trust rights. But in your yard over here, in the woods, you've got all those rights in your bundle of sticks, right? So essentially, going back to what an easement is, it's a stick out of your bundle that, in this case, would be if you had the right to limit somebody from doing beach nourishment on your property, you would be giving them the authority to do it. And that's it.
And it's limited to what's spelled out in the easements. For example, a power company who takes a 50-foot wide easement on a 10-acre tract of land, they can't then go in there and build a road.
They shouldn't be able to, no.
Because the easement specifies it's for, ideally, it's not a blanket easement, it's for a specific purpose.
Correct. And to be accurate, it comes down to the actual language of the easement.
Right.
The reason I say that in particular is because there's a weird case related to a power line easement and some ingress and egress associated with it, but it came down to the language of what was written there, and that's what it comes down to.
I have two questions, and I think I'll be done. The first question is more like, can you narratively tell me a story of like, what will this function like in real world? Let's say we have 10 or a dozen property owners that don't voluntarily grant us an easement, and we just walk me through this process so I'm aware of the authority that we're seeking and what it will look like real world for our citizens.
Well, I think at some point there will be, so you're saying there's a handful of folks who don't grant voluntary easements.
Yeah.
At some point, that'll come back to the board, and the question will be, what do you want to do? And you'll have to either balance, do we want to modify the project? Do we want to file condemnations? Do we want to do the project anyway and deal with what could come of that? Do we want to file a different kind of suit to confirm our right to do this without condemnations? And that will come. And if the ultimate choice in all of those is to file a condemnation, see if I got something that gives me a little bit more here. I think you gotta, I wasn't completely prepared. This is stuff to do well into the future. But you gotta adopt a resolution authorizing the taking of the easements via condemnation. You gotta mail notice. There's a period of time that you've gotta wait, and that the holders of the easements or the holders of the landowners, in that time period between sending that notice, they can file for injunctive relief. Let's see. Then time comes and we file a complaint with the clerk of court and make a deposit for the estimated compensation, and then we go to court. But as soon as the complaint is filed, if it's the day before your project starts and you got to be on that property the next day, then the contractor can be on that property the next day. Yeah, you would condemn an easement, and it would probably be even more limited than what you would ask for voluntarily. I mean, that's the history that I've seen, is that for voluntary easements, they're a little bit more broad, and then if you do have to condemn, the more recent ones that I've dealt with have been a much narrower a very narrow, very, very narrowed easement.
It's already there.
Well, it wouldn't work for a playground, because, yeah, because a playground is not in the quick take authority, in the accelerated process authority list under A1. But it would work, if you wanted today to condemn if you adopted a resolution to widen a sidewalk on somebody's property, you could do that, and you could go through that process, and, yes. It's a really painfully complicated statutory setup that every time I look at it, it takes me a read or two, but I have the benefit of having in the back of my mind, having dealt with it a number of times, how it works, so I can get there. But it is a puzzle, and I don't know exactly why the General Assembly likes it this way, but ultimately they probably do, because to modify it, it's a lot simpler by just adding a town name than to actually modify it to make it so you could read it and understand it would be much more complicated. The modification would be. Yeah, I mean, those are already authority that you have. Yes. Yes. It's an awful way for the General Assembly to do it, but that's what it is. Yes, sir. Yes.
We'll be gaining quick take authority for 10 these access. We are deliberately excluding ourselves from the subdivision level.
Yes.
And we would never be able to gain for 2, 3, 5, 6, 8, any.
I wouldn't say never, but yeah, but you're not asking for it, and nobody else has it that I know of. If somebody else has it, it's in a local bill somewhere. It's not in the general statutes. And Mr. Mayor, the one last thing, another mistake by me is that in your resolution, the resolution that might be in your packet, in the title, it left in 11, despite the fact that the substance took out 11. I would say you may want to modify the motion to amend the resolution that's in the packet to fix the title, so it's just referencing 10. The substance just references section 10, but I missed a little portion in the title where it kept the 11. Yeah. Yeah.
So the motion, I would like to make a motion that we adopt the resolution as amended by removing the and 11 from the title of the resolution. That's 11, right?
Yes, ma'am.
To consider adoption of certain legislation authorizing the sale of private property for the purposes stated in GS 48-3, B1, 10, and be able to make such applications to the allowed by GS
I'll second that.
Cliff.
Mine died again.
Cliff, I kind of latched on to one of the last things you said. I would suggest the staff doing that because committees are where issues go to die or to take forever to get done. And, I mean, this is a pretty straightforward process, relatively. But just let the staff do it, and then, like you suggested, come back to council before they're all sent out.
And maybe along with that easement, we'd come back with the FAQ.
With what?
With just a form, standard FAQ that maybe
Yes.
addresses some of the questions.
Yeah,
Yes.
frequently asked questions.
And I think we can make the initial request for easements soon, follow that up a few months later with another request, and at some point, we've got to give the notice if we are going to, have to do the condemnation. Maybe the third request would be, please sign this easement. The next step, you have to give 30 days notice, I think, before you actually condemn. The third request could be to also notify that the need to condemn.
we've got to get, this resolution has to get through the state legislature, so my question is, are Hannick and Steinberg aware of, has there been conversation with them? Is there going to be, this is, I don't think, a short session, so, and then it has to be heard 3 times over there, so, you know, there's a little delay in this getting, it's not going to get approved tomorrow.
I think the mayor has had conversation with both our representatives about this coming forward.
I've actually talked about, to Representative Haney, I've not talked to our senator. I did talk to someone in his office who said he would relay the information to the senator and would make sure he knew exactly what to expect. I told him they should be anticipating receiving a resolution from us sometime after this meeting. And before their next session, but I was also told that they both either Mr. Haney and also Ned Stiles from the senator's office said the same thing. We'll probably deal with this in January.
I thought they were going to hear it in September.
No, it's never, they never
So
told me.
we got a little, I'm gun shy from the last time we went down this road and what happened to us.
I was there too.
Yeah, you and I are the only 2 here that remember that, and the rug got pulled out from under us, and that's what I don't want to see happening again.
Yeah. Well, whether it's an accelerated process, where they do it in September or they do it in January, they're still going to do it.
Yeah,
And
well,
obviously you're going to have,
hopefully.
obviously you give people who are going to object to it a little more time to do so, but we can't control that. I can't dictate to them when they're going to handle this for us.
well, for some reason, I thought they were it would be introduced in this session coming in September.
Well, I had hoped they would consider that, but I got a very clear message that it would be in January. Now, I can
Their
always,
docket must be full then.
Leo, I can always go back and say, would you reconsider? And I'm glad to do that.
I'd just like to have it finished.
Well, I agree
Can we
with that,
go,
but-
I'm sorry.
No, you go ahead.
Can we go back to Mr. Ogburn's suggestion to authorize staff to go ahead and start a process for the voluntary
That was
easements?
the motion I made,
Yes.
and that motion's been seconded. I believe.
Let's vote. Let's vote.
I'm happy to vote.
So as far as, this is more discussion, I'd say call for the vote, all in favor of having the staff handle this process of seeking these voluntary easements, indicate by saying aye.
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 The motion's made and carried to have staff work with our town attorney to seek and acquire as many voluntary easements as possible from our remaining oceanfront property owners. And it's carried unanimously. Thank you. Any further business here? Let's go back to the agenda. Time for council comments. I'll pass that around to you, Elizabeth, if you have something you want to say.
I'm good, Mr. Mayor, thank you.
I don't have anything today.
Matt,
Nor I.
I've said enough. Need a motion to adjourn?
So moved.
A
Second.
Thank you. All in favor?
Aye.
Aye.
Meeting's adjourned. Thank you.